You've decided that you finally want to get a will, or you may have spoken to your parents, siblings or friends, and they have been talking about wills to you, which has inspired you to get one done. Having your affairs sorted, especially at an early stage, is one of the most beneficial things that you can do for yourself. In order to prepare your will, your solicitor will need to know the following basic information: your executors, your beneficiaries, and how you want your estate to be distributed. But there are certain things that can go wrong in the process. I want to focus on these things and help you know what to look out for when preparing your will. Number 1, make sure that you consult with your executors and that they know that they're being actually appointed as your executor. In many common situations, an executor is generally a family member or sibling. Quite often we get asked whether your executor can be your beneficiary as well. Of course they can, but please make sure that that person knows that they will be an executor of your will. Number 2, make sure you have the right structure for your will. A will needs to cater to your individual circumstances. For example, if you're a business owner or you have some form of company structure, it is best advised to have a more complex will prepared. A complex will ensures that company assets or your share in a company is able to be legally passed down to your beneficiaries, often in the form of a trust. If your will does not have any of these provisions that create a trust upon your death, then it will be very difficult to claim this asset as part of your estate. Number 3, don't leave it too late. Far too often, we get calls from people asking to have their parents' will prepared. They tell us, my parents are old, they're frail, and they need to get one done. One of the worst things I have people tell me is, my parents are in palliative care and they don't have very long to live. A will is only valid if the person signing the will has the proper testamentary capacity, meaning that they are of sound mind and understand what it is they are signing. If we believe that a person signing a will does not have this proper testamentary capacity, then we simply won't allow the person to sign the will. If you want authority to have a will signed for a person who does not have testamentary capacity, then you may need to seek court intervention. And finally, the will does not carry out the testator's intentions. Now, if you aren't able to understand your will yourself, then chances are your executors won't either. Make sure you speak to your solicitor to make sure that the will carries out your intentions. If it doesn't, then again, you may need to seek court intervention in order to rectify this error. At JB Solicitors, we understand the things that can go wrong when preparing a will. We ensure that you have a will that is specifically tailored to your situation and clearly outlines your intentions to make things smooth for your executors. I hope you found this information valuable. If you need more information on this, please give us a call or visit our website.